All right, we're going to go ahead and start. I want to introduce myself very quickly. My name is Anthony Prince. I'm one of the attorneys. My co-counsel is with us tonight as well, Andrea Henson.
Hello, everyone.
Okay. Thank you, Andrea. We're going to proceed, but we want to begin tonight by allowing our Western Regional Director for the National Union of the Homeless. You guys know who she is. Many of you know Crystal Sanchez. She's the president of the Sacramento Homeless Union, and she has been part of our team that has worked assiduously almost for 3 straight weeks to organize, reach out, and assemble the complaint. And so we want to just give Crystal a couple of minutes to make some opening remarks, and then we will start the press conference. Crystal?
Thank you, Anthony. So I'm going to read something to you guys really quickly. We'll allowing time for people to come in. So first of all, dear friends and fellow community members, we gather today in 2025, but the echoes of history ring loudly in our ears. Nearly a century ago, the Great Depression, 1/3 of all Americans were just one missed paycheck away from homelessness. Then, as now, the response of many cities was to not help, but to criminalize homelessness and to criminalize poverty, creating vagrancy laws that made it illegal to be poor and unhoused. Now, as then, communities faced a choice. Would they turn against their neighbors who had lost everything in economic circumstances beyond their control? Or would they stand together, as Americans did in creating Hoovervilles, mutual aid societies, and community kitchens? Let me be clear. We are not here today as helpers or saviors. Just as the neighbors who shared their tables during the Great Depression weren't charity workers, but equal citizens helping each other survive. We're here as equals, standing shoulder to shoulder with our neighbors who happen to be living without permanent housing. History teaches us that criminalizing poverty has never solved it. When cities passed the anti-Okie laws during the Dust Bowl migration, it didn't stop people from seeking a better life. It just made their suffering worse. When cities used sundown towns laws and moved along policies against civil rights activists and the poor, it didn't dissolve social problems. It just revealed the moral bankruptcy of those in power. These ordinances don't just attack our unhoused sisters and brothers. They attack the very fabric of human connection that helped America survive in its darkest hours. During the Depression, it was illegal in many cities to share food with the hungry. Today, Fremont tries to criminalize the same basic human solidarity that saves countless lives in our past. When a mother shares food with another mother's child, it is not charity. That's the same human spirit that created community soup kitchens in 1931. When a veteran stands with another veteran who's fallen on hard times, that's not helping. That's the same solidarity that got us through 2 world wars and the Great Depression. The City Council has revealed something profound with these ordinances. Just like those who passed the anti-Okie laws, they've shown they believe some people are worth more than others. We reject this lie completely and absolutely, just as history has rejected every attempt to criminalize poverty. Let us remember, during the Depression, it wasn't government criminalization that helped people survive. It was neighbors helping neighbors. It wasn't vagrancy laws that restored dignity. It was communities standing together. The New Deal didn't succeed. It punished poverty. It succeeded because it recognizes that society's strength lies in lifting everyone up together. This is not a movement of charity. This is a movement of standing together, just as we the people have done in every great crisis. When the stock market crashed in 1929, communities didn't criminalize their neighbors who lost everything. They stood with them. During the 2008 financial crisis, communities didn't punish those who lost their homes. They organized to defend them from eviction. Today, we don't stand for each other. We stand with each other, continuing proud traditions of community solidarity in the face of crisis. And we will continue to stand together until these unjust laws fall, just as every other attempt to criminalize poverty has fallen before them. This is our stand. This is our truth. And this is our commitment to real community, one based on the time-tested values of equality, not charity, solidarity, not saviorism, but justice and not judgment. Just as our grandparents and our great-grandparents stood together during the Depression, we stand together now. Because The arc of history shows us the undeniable truth. When communities criminalize their neighbors, they fail. But when they stand together, they survive and they thrive. And with that, I'm going to introduce Anthony. Anthony Prince is our lead general attorney.
Well, first of all, I want to thank everyone for attending this press conference. And we are prepared to give a report on the status of our lawsuit and an update on discussions that we've had, very minimal discussions, but some with the City of Fremont, and report the results to the where I'm permitted to do so, of a very short meeting that we had with the judge that's been assigned the case, Judge Maxine Chesney, one of the more experienced judges that we have had cases with, Judge Chesney in the Northern District before, and I'm going to make a report on that status. I'm going to apologize in advance for sounding tired. We're all tired here. All of us who have worked so hard on this lawsuit. It's a 62-page brief, a complaint and a motion for preliminary injunction. I believe it may be the longest and most detailed complaint that we have filed in the 10 years that that the California Homeless Union has been around, organizing what is now up to about 25, 26 local unions up and down the state with thousands of members. So let me begin by saying that let me correct a false impression that's been created because of a story that appeared in the San Francisco Chronicle. The San Francisco Chronicle ran a story reporting that the judge had issued an injunction against the City of Fremont, ordering the city not to enforce the ordinance which it enacted on February 11th. That is erroneous. There has been no order from the court. The only order we have gotten from the court is to appear as we did at the scheduling conference. At the scheduling conference, the judge did not issue an order. However, we did have a discussion, and it was agreed that the city attorney would make a recommendation to the City of Fremont not to enforce this ordinance until at least March 18th. That's only 10, 11 days away, but would hold off on enforcing until we get a look at what they say is going to be an amended ordinance. So I want to be clear that there is no order in place that restrains the city. The judge has not decided one way or the other on our motion for a temporary restraining order and a preliminary injunction. If we are unable to support the ordinance, if we do not see the changes that we think would make it constitutionally appropriate, we will so inform the court, and we will proceed with a briefing schedule, which means that we will file, and most likely the court indicated that we would be permitted to file an updated, amended complaint, and if necessary, pointing out, which we intend to do, the continued existence of unconstitutional components. It is our opinion that this measure Chapter 8.90, is unconstitutional on its face, and it cannot be rescued. And I say that because there is a widespread, this is the other issue that we want to clarify at the outset, which is that the city has gone out of its way to reassure organizations that are traditionally supportive of the unhoused, churches, faith-based organizations, charity organizations, community groups, and the homeless themselves, and falsely reassured everybody that they would not be subject to a arrest and prosecution for doing what they normally do with regard to distributing food and clothing and other things, and that the city intends to amend the ordinance now and delete that particular section, which directly implicates aiders, abettors, and those who might conceal violations of the ordinance. So what I'm trying to say here is that we have learned now that this city has, it does intend to submit on March 18th. Presently, their intention is to submit an amendment which will delete that section of the ordinance, but will leave in place the essential core of the ordinance, which is to deepen the criminalization of the unhoused in the city of Fremont. I'm going to walk you through some of these provisions so that you understand exactly what is at stake here. The other false perception that we want to clear up right away is that there have been statements on the part of the city and other officials, and including in the media, that this is no different than what is already on the books, and that some of us are going around trying to panic pedal and make people believe that this is somehow more draconian and worse than what is already in the Fremont Municipal Code. Well, I would say, first of all, that if it's already in the code, why do we have this ordinance? Why did the city find it necessary to enact this ordinance? The fact of the matter, we're going to walk through it. The fact of the matter is that this ordinance is very different. It is qualitatively different, and it is substantially, it takes a 7-league stride down a more dangerous path of making almost the very existence, without more, of a homeless person outside a criminal offense. And we'll go through the specifics in just a couple of minutes. So I've clarified the fact that there's no order in place now. I've announced that the two sides have met. I spoke to the city attorney today on the telephone for a very short conversation, and our position, as everyone who's familiar with our union knows, that we would prefer to sit down with city officials at a table and discuss ways that we can come to an agreement that will satisfy both sides. We think that the city has obligations to all of its residents, including its unhoused residents. We also think that it's true that the city has interests that it needs to be mindful of. We have interests as well. Our interests include being able to get food, being able to have shelter, being able to survive, and being able to receive the assistance and support of organizations, fraternal organizations, church groups, faith-based, and various organizations that have whose purpose it is, their mission is to assist the poor, to assist the unhoused. And so I've updated you on those in developments. We do not have a court date yet, but we will likely have a court date to return to court after March 18th. On March 18th, when the City Council votes on the amended ordinance, we will take a look at that ordinance as it comes out of the City Council on March 18th. And I can tell you now that if it still has in it, which of course we believe it will, unchanged, the essential elements of the criminalization of the unhoused, we will go forward with our lawsuit, and we will go forward with our motion to seek a restraining order, and that will then be before the court. What you're looking at here, I would ask everyone to pay very close attention to what you're looking at. On the left-hand side is, and I'm going to read it, it said that what this is what is currently in the ordinance that was enacted on February 11th. It says, Section 8.90.060, Enforcement, subsection B. Number 1, any person causing, permitting, aiding, abetting, or concealing a violation of this chapter shall be guilty of a misdemeanor and may be prosecuted as a misdemeanor, and upon conviction be subject to a fine not to exceed $1,000 or imprisonment in the city or county jail for a period of not more than 6 months, or by such fine and imprisonment. That is language that is in the new ordinance under, as it says, Section 8.90.060. On March 18th, the City Council is going to vote, and almost certainly they will vote to delete this language, and only this language. from the new ordinance. On the right-hand side of the screen is a clause which is in the Fremont Municipal Code and has been in the Fremont Municipal Code for years. It is a standard clause which appears in many city codes, municipal codes. I'm going to read it. It's in Chapter 1, and it's 1.10.040. It's entitled Prohibited Acts, including causing, permitting, or suffering. It says then, whenever in this code any act or omission is made unlawful, it shall include causing, permitting, aiding, abetting, suffering, or concealing such act or admission. And that's the 1990 code. The title of that part of the slide says this clause is permanent and will remain in the code. Now, in my conversation with the city attorney today, it was confirmed that the city council has no intention of removing this language from the Fremont Municipal Code. In other words, the language that they're going to take out in order to represent to the community that organizations will not be subject to arrest and prosecution if they...
Recording in progress.
The language that is in the ordinance now that has brought the most attention and has provoked the most outrage, deservedly so, and opposition, they're going to remove that. But what is going to remain in the Fremont Municipal Code is the language I just read. So what does that mean? That means that this is an illusion, that this is I have to say, tantamount to fraud, to represent to the community that, and the supportive community, the organizations, which are many of them part of our lawsuit now, that they will be immune from prosecution. They have nothing to worry about. So let's be clear on this. Let's be absolutely clear on this. If someone assists a homeless person in a manner that is prohibited, provides something to that homeless person such that that person has it in their possession, whether it's a tent, a bedroll, a blanket, a pillow, a little cook stove, a box of sandwiches, whatever it is that can be arguably helping to maintain an encampment, is subject to arrest under this code section. The City Council is not going to delete this because they can't delete it. No city can simultaneously enact a criminal measure. No city council can declare, no city can say something is now unlawful, and yet it's okay to assist someone in violating that law. I hope people understand what we're saying here. I hope people understand what we're saying here because we believe that a very, I don't know exactly what the intent was. It doesn't matter what the intent is, but the fact of the matter is that no one should feel any safer by the deletion of the language that's in the new ordinance. Because this language here fully empowers the city to arrest and prosecute those who aid and abet another person or party in the commission of a crime. And maybe right now you hear a lot of public statements from various city officials. Don't worry, you're fine, you can do what you're going to do. But what happens if a new city council, what happens if the pressure that we see all across this country to sweep the homeless and get rid of these encampments? What happens if a police chief comes in and decides that he's going to show who's boss? They have the absolute legal authority under this existing, long-standing code section to make those arrests, not just of the unhoused who are going to be in that tent and sleep on that bedroll and inside that sleeping bag, but the person that supplied that tent, that bedroll, that sleeping bag, that tarp, that person will also be subject to an arrest. Aiding and abetting is not an independent crime. Aiding and abetting is a route. It is what enables a prosecutor to arrest not just the person who broke the law, but the person that assisted that person in breaking the law. There are dozens and dozens of organizations that we've talked to in the last month, many of them in the city of Fremont. And some of them have said, well, our primary concern is we want to be able to continue doing what we are doing. You may be able to continue what you are doing, but you will be running the risk of arrest and prosecution under this code section. So the position of the Homeless Union is that so long as this remains in the city code, and so long as what we have now before us, a facially unconstitutional ordinance that greatly expands the prosecutorial powers, greatly enlarges the definitions to a point where they're so broad that simply being a homeless person outside is, on the face of this ordinance, a crime. Let me point out a few other things. And what we're going to do is anyone who has not received a copy of the complaint, I'm going to give out my email, and if you contact me at that email, we'll see to it that you get a copy of the complaint. And that's princelawoffices@yahoo.com. I'll say it again, princelawoffices@yahoo.com. And if you send us an email, we'll turn right around and send you a copy of the complaint. We'll send you a copy of the minute order that was that Judge Chesney released after we had our scheduling conference. And we'll send a couple of newspaper articles that have come out, which we think did a good job in covering this issue. What I want to share with you now is something that's attached to that complaint. It's the exhibit to the complaint. And so those of you who have it might want to follow along. I don't think we were able to get it up on the screen. But please avail yourselves of this, the complaint and Exhibit A, the only exhibit that's attached to the complaint. And I want to go through some of the definitions that are used. Let's take the definition of camp. Here's how the city is defining camp in the ordinance, and this would remain in the ordinance if they, no matter what else they delete. It says camp means to place, pitch or occupy camp facilities, which are defined in the next section. Pitch or occupy camp facilities, semicolon, to live temporarily in a camp facility or outdoors, semicolon, or to use camp paraphernalia. I'm going to read it again. Please listen carefully. Camp means to place, pitch, or occupy camp facilities, semicolon, to live temporarily in a camp facility or outdoors, semicolon, or to use camp paraphernalia. So let's focus for a minute on that second clause, to live temporarily in a camp facility or outdoors. On its face, this clause of the ordinance in subsection 8.900220, the definitions, facially makes it a crime to live outdoors. There's no definition of what live is. There's no definition of what outdoors is. And when you don't have definitions, the court will look at the ordinary and plain meaning of words. And the ordinary and plain meaning of the word live is to be alive, and the plain and ordinary meaning of outdoors is being not indoors. So on its face, the very first definition that's provided here criminalizes the act of being outdoors. And the city, which is taking the position that this is a neutrally worded ordinance. In other words, it's not targeting the homeless, it's for everybody. You can see how broad, overbroad this sweeps. Now it's true, who else is going to live outdoors? The homeless. So it is targeting the unhoused, even though it is worded in what we call a facially neutral sense. But what is not, but what is also facial is the criminalization of living outdoors. We have not seen, and please, someone correct me if I'm wrong, we have not seen a definition of camp that includes the act of living outdoors in any prior ordinance or code section anywhere in California or in the United States. And I will say that this is not just semantics. This is the law does not, and when you have a statute or an ordinance or a legislative enactment, every word has meaning. Semicolons set off independent clauses, and that is an independent clause, that it is now a crime to live temporarily in a camp, facility, or outdoors. All right, let's drop down to the next definition, camp facilities. It reads, camp facilities include, but are not limited to tents, huts, vehicles, vehicle camping outfits, or temporary shelter. Well, you've got it up on the screen. Great. So let's talk about that for a minute. First of all, we have the but are not limited. This is language we see many times in legal documents, and it said what it is that language like this empowers, enables the legislative body to expand the definition of that particular clause. In other words, now they're saying that camp facilities include tents, huts, vehicle camping outfits, or temporary shelter. But they're not limiting themselves to just those identified items. So they are now preserving to themselves, on the face of this ordinance, the ability to expand that list. We have homeless people living in, obviously, in tents, huts, vehicle camping outfits, and certainly living in temporary shelter. But we also have them living in abandoned houses. We have homeless families doubling and tripling up with other families. We have 15% of college students in the United States are homeless, and many of them sleeping in the universities. They're sleeping in the parking lots. We have people in their RVs. We have people in boats. We've had boats seized and destroyed as marine debris, forcing people onto the land where they then have to camp out of necessity. So the point here is that by using this, giving themselves permission to expand it in whatever way they wish, what is regarded as a camp facility is highly problematic. Also, let's take note that it includes temporary shelter. What they're saying, and we live in a state where Governor Newsom declared a shelter crisis. That was a legislative enactment. A shelter crisis act was enacted, as you know, during COVID-19. And our union went to court in at least 3 cities where we were able to persuade the court that a person in a homeless encampment was protected by the Shelter Act. Not to mention those who are actually in shelters, whether they're operated by the Salvation Army or St. Vincent de Paul or Abode Services or any number of shelter operators. On the face of this ordinance, it is a crime to be in a camp facility, and the camp facility includes a temporary shelter. So on its face, it runs afoul of a previous legislative enactment. Whether or not is in effect is not the point. The point is that we have shelters, we have homeless union locals in shelters, and we have hundreds and thousands of people in shelters. So this says that you are subject to arrest if you're in a temporary shelter. Now, it could be argued that those are permanent shelters, but in any event, the ambiguity here, I think, is problematic. Let's drop down to camp paraphernalia. Again, paraphernalia includes, but is not limited to, bedrolls, tarpaulins, cots, beds, sleeping bags, hammocks, or cooking facilities, and similar equipment. What is similar? What is similar to all those items? A blanket is similar to a sleeping bag, a pillow, a bedroll. How about a food that comes in a box? How about medication that has to be refrigerated, and so you don't have a refrigerator So you have a cooler with ice in it. All those things are arguably fall under the definition of camp paraphernalia because of this overbroad definition. Let me also point out that let's talk a little bit about food, and let's talk about clothing. And let's talk about an expression which has been in the universal language of the world for time out of mind. Food, clothing, and shelter. Food, clothing, and shelter. Those are basic necessities of human existence, some kind of shelter. Even the caveman sought and obtained shelter. But if you are in the city of Fremont and this ordinance is enforced, and someone comes up to you and gives you a box of food, and you don't have a way to keep it fresh, because that might fall under the definition of paraphernalia, then you got a problem. If you have clothing and you can't be in a tent because it's illegal for you to be in a tent in a public space, then that clothing is going to be subject to rain, heat, bugs on the ground, and spoliation. If you have anything which is at risk along those kind of lines, you're going to have a problem here. And so what we're saying here is that you cannot separate. The city has gone out of its way to reassure certain organizations, oh, no. All we want to do is prevent people from going in and putting up tents and structures. You can go ahead and donate your clothing and your food and whatever else you might do. We're here to say that you cannot draw there might be a distinction, but there is no difference. Because those items that are provided to you are not worth much if you don't have a way to safely preserve them so that they're accessible to you. Let me also point out in the definition of equipment, moving equipment, I would argue that a wheelchair could be found to be a moving equipment. I would suggest that an assisted mobility device could be found to be moving equipment. It could also be include within that very broad definition a trailer. Who knows? The fact of the matter is that we have seen wheelchairs thrown into dumpsters. Everyone here knows that. We have seen the city crush wheelchairs, assisted mobility devices, and other items which could arguably be considered equipment. And now we've codified that. The City of Fremont has codified that in this ordinance. We are not going to rest assured, and I don't think any organization that is genuinely committed to helping the homeless, assisting the homeless, should rest assured that they're out of the line of fire. And more, just equally important, let's not forget who we're trying to serve here. Let's not forget, and let's consider a scenario where the tent or the other survival item that you provide to a homeless person could become an instrument of crime, an instrumentality of crime per this ordinance. And I'm not talking rhetorically here. I'm talking in terms of what is actually expressly provided in this measure. We want to take questions from the media. This is a press conference. We want to give priority to reporters, the regular media, the community media, and we definitely want to hear your questions and answer your questions. Andrea?
Thank you, Anthony. I think everything you shared was very thorough and important. And we know that this particular ordinance specifically not only focuses on volunteers and the unhoused, but also is having a chilling effect on anyone who wants to provide blankets, sleeping bags, tents to folks on the street. However, many people who, for example, are in churches or are in recovery programs who are convicted to go live out their faith, many times have reformed their lives and don't want to have interactions with law enforcement. This has a real chilling effect. And so we're going to fight very hard, both for those who are unhoused, for our plaintiffs, and to make sure that people can continue to live out their faith and to live out their political convictions. And as Anthony mentioned in talking about this ordinance, being unhoused, providing tents and cots and food go together, because you can't have privacy without a tent. You can't protect your clothes and your food from rain and wind and wetness and mold. It helps people to protect them from hypothermia, to protect their food, the storage containers. This particular ordinance makes it criminal to store property, your medications, your food. It protects people from rats, from being exposed to various diseases and things that could affect them if their possessions get really wet, if they're exposed to extreme temperatures, especially if you're disabled, if you have conditions, as we saw in Sacramento, many people have seizures, and different types, extreme weather can set that off. We see that throughout the state. So that's why it's so important that we look at all of these things together, because of the impact. You give out tents so people can have protection from the elements, so that they can change their clothes, so that they cannot be seen, so that they can protect themselves. So now I just wanted to add that. That's why it's so important. I thank each and every one of you for standing up and supporting this lawsuit and supporting your community. And now we'd like to take questions.
I'm just asking, what's the case caption? Not the caption, the case number?
Oh, I can tell you that right now. It is 3. I don't know if it's colon. I'm sorry, I'm so tired. The 2 dots. What is that? It's a colon. It's not a semicolon. Colon. 25 hyphen CV or dash 02225 dash MMC. The MMC is the judge's initials.
I've got a couple of questions. Number one, I was unclear. Even if the city is removing this aiding and abetting from the ordinance and it's permanently remaining in the code, are we taking any action to try and alleviate that if it's permanently in the code? Or are we just warning people not to assist? That's question number one. Number two, I am concerned about the, in particular, the definition of paraphernalia, which reduces personal property as protected under the Constitution, now making it contraband and perfectly legal to remove and destroy personal property that is necessary for life. And so I'm wondering, how are we getting around this?
Those are excellent questions, Catherine. Let me first, in terms of the, and I'm glad it seems that people are understanding the reality that they can take this aiding, abetting, and concealment language out of the new ordinance, but it remains in the code. And so the answer is that there is only one way, in our view, to see to it that no one is at risk for aiding and abetting a crime, and that is to find that criminal, the enactment of that criminal law is unconstitutional. And that's how we're proceeding. There really is only, from a legal standpoint, so long as this, the ordinance criminalizes the conduct which I just described, anyone who conceivably assists in violation of that ordinance is subject to prosecution, is subject to arrest and prosecution and punishment. So there is no other way. There is no fix to this. And I want to stress again that if people are are understanding here what's going on, they need to join with us and insist now that taking out this language from the new ordinance is not enough. To answer the other part of your question, I believe the city cannot take this, the code section 1.1001, in other words, the overarching language which requires the city, if it makes something unlawful, then it must also, the city also classifies those who assist in that crime as accomplices. They can't remove that because that's the California Penal Code. No city can enact a law that says this is against the law, but if you help someone violate it, you're okay. You won't be prosecuted. There is no way to get around that. And in my conversations with the city thus far, they recognize that clearly, and they have no intention of making any alteration. And I don't believe that they could make any alteration. And they're not. In any event, they're not going to. And so, what are we going to do? Catherine asked, well, what does that leave us to do? I think the most important thing, what it obligates us to do now, is to turn our attention away from this illusion that they've created here, and turn our attention to the ordinance itself. It's unconstitutional. It needs to be repealed. Now, having said that, and I failed to mention this, but I want to mention it because it's important. Having said that, we are willing, and I let the city know today, that we are willing to come to the table. We are willing to take a look at whatever needs to be examined by way of the city's obligations, issues of public safety, issues of community, the community's well-being, issues of protecting aspects of our city and our infrastructure. We're willing to look at all of that. We understand the city's concerns. The city of Fremont did not create homelessness. Homelessness is a systemic issue that is tied to the economic order in this country. The market is the highest return on the investment is not going to go to create housing for poor and working class people, and we can see that it's not. And so it's a systemic thing, and the city of Fremont did not create the housing crisis. However, at the same time, it is certainly not helping to assist those residents who are impacted by that housing crisis. And so we're willing to sit down and find common ground. We have done that in Novato. We've done that at least for a time in Sacramento. We've done it in Sausalito. We're doing it in other cities where it's the realization is, and I will point out that there are other cities across the country, many cities, increasing number of cities, by the way. On the one hand, you have cities that are trying to get rid of the homeless and are see the grants pass decision as a green light, that there's no further restrictions. On the other side of the equation, we are seeing cities that are taking a different approach. They're realizing that these are people that, for the most part, lived their lives in these cities and contributed to the wealth of those cities and raised families in those cities and are residents of those cities. And therefore, they have to take the approach of what are we going to do about seeing to the safety and security of those unhoused residents of this city. No less entitled to protection, no less entitled to their personal items, no less entitled to be free of government actions which increase the risk of their harm. And so that is the attitude that we want to bring to it. We are not a litigious organization, even though we have a reputation of being litigious. We're only litigious when we are unable to reach an agreement. And I think as adversarial as it's been, as much hostility has been manifested here, we've seen some statements coming from members of the City Council which are highly inappropriate. I will share with you that we're already seeing on social media threats against some of our named plaintiffs, and they're not on this call tonight because we indicated that they should not show their faces. This is a very serious matter, and we think that the city needs to be as concerned about it as we are. And so we're willing to sit down. We've made that overture. I was told by the city attorney that the proposal to let's convene as soon as possible a gathering where we can take a look at this ordinance and see if there's any possible way that it can be altered, modified in such a way as that it increases the safety of the community. We don't believe it's possible. I don't think that this as it currently exists, that it's possible to do that. But I'm not going to slam the door on it. I've looked at this. We've done this in other cities. We're concerned about the safety of the community. We're concerned about our rivers. We're concerned about our parks. This is as much an interest. We're certainly interested in protecting people from crime and violence as much, if not more, than the city. And so we think we can find some common ground. And we're not just saying this either. We mean it. We're ready to put a pause on our litigation if the city will agree to put a pause on the enforcement of this ordinance until such time as we can exhaust every possible effort to come to some kind of agreement.
Anthony,
so just a minute. Let me just finish. But I will also say that the Homeless Union, we are not going to be deterred no matter what. And I'll be quite frank with you. We are guided by Dr. King, Martin Luther King, who everybody likes to hold up on one day in the month of January. But we hold up Dr. King 365 days a year. And Dr. King said that unjust laws should not be obeyed. I'll leave it at that. We are not going to let the members of our union, and there are thousands of them, we are not going to let our members suffer because of this enactment. We are not going to allow those who want to assist the homeless to be deterred, and we're going to make every possible effort to see to it that we are support to the homeless, our organizing of the homeless, the self-organization of the homeless, the right to take measures, rudimentary precautions to protect yourself from the elements and whatnot, to see to it that will go forward unimpeded. We've been down this road before. As Crystal pointed out, and I appreciated her historical analogy. We've been down the road. We've had people go to jail. We've had people even beyond going to jail. We've had people pay the ultimate price for the defense of these constitutional rights, and we're not going to bow down. If for some reason that this measure remains and we don't get the relief that we seek, we're going to continue to do what we've been doing all along. But I have some hope that what will happen instead is that we will see the organizations that have been out and absolutely justifiably organizing around this because their organizations want to help and they don't want to have to go to jail for helping. We want to see those organizations, the 501c3s, the churches, shifting over and now focusing all their attention on getting rid of this ordinance in its entirety to stop the criminalization of the people that they want to help. We want it so that you can provide those things to people and they won't be at risk for possessing them. And so we call upon the organizations in the city of Fremont, in the South Bay area, in California, across the country. We're getting contacted from, today I got 3 calls, one from Pennsylvania, one from Washington, D.C., and one from Missouri. Organizations want to come in. Can we file an amicus brief? Can we get with this thing? We're facing the same things here. I call upon the organizations to talk with us, get on board, and the demand at City Council meeting on March 18th is that no deal, repeal. Repeal. That's what we're looking to do, and I think we succeeded. Let's recognize what happened here. Under a lot of community pressure and national attention, condemnation in the mass media, and people coming out and saying this is wrong, they had to back down. That means we can back them down all the way, and we have to back them down all the way.
A couple of questions. I don't know if you can even speak to this because I know it might be considered like a strategy or something. But I know you said that you were talking about going the constitutional route with this. And in the past, when there have been similar cases, I believe actually you were the one who told me this, Anthony, was that one of the ways that it was tackled was by looking at it from the perspective of like First Amendment, freedom of religion, these organizations, some of them are faith-based, and maybe looking at it from from that perspective, can you maybe shed some light on how it's unconstitutional, and just the different ways that that's the case, and or if that's something that's, like I said, strategy, and you're not able to talk about it. I understand, but I'm just curious and as to the different ways that it's unconstitutional, because there's a lot of ways that it could be.
Yes. If you read the complaint, and we'll provide everyone with a copy of the complaint that contacts us, you'll see that we are raising those constitutional aspects: freedom of the First Amendment, freedom of speech, and this is conduct that is speech. The Supreme Court, it's well settled law that it's called expressive conduct. You're carrying a message by your conduct. Free expression, free exercise of religion. This is a constitutional right, and I want to single out our faith community plaintiffs here. I want to single out the Mission Peak Unitarian Universalist congregation, which stepped up to become an organizational plaintiff in this case. They did the right thing, and they did the courageous thing. And I want to single out Pax Christi. We made a mistake. It's actually Pax Christi, Northern California, and that's the organization that's agreed to be a plaintiff in this case. Braided Bridge, Homebridge, Connect. And then we want to talk about the Faith in Action organization out of the East Bay, and of course our own local unions. But we want to lift up these organizations, and we want to see, and we encourage others now to join the lawsuit. We will almost certainly file an amended complaint, and we are permitted to add plaintiffs, individual plaintiffs and organizational plaintiffs, and we're permitted to add additional causes of action. But yes, we are asserting violations of the Americans with Disabilities Act, the First, Fourth, 14th Amendments, Fifth Amendment, Takings Clause. Every single constitutional protection is implicated here. We have put it into our complaint.
I just wanted to make a point as well as ask a question. How? So I know individual who aided a homeless person with getting a job while homeless, and he was homeless for like 4 years, and as of August 1st, 2024, he is no longer homeless. That person being me, myself. How is a person supposed to even make it out of homelessness with policies like in Fremont, if such a thing gets passed?
That actually is an excellent point, because the fact of the matter is that how can you even get on a pathway to housing?
Yes.
If you're being constantly pushed out of one place to another. We have found, in fact, that encampments can become staging grounds for housing. You get the paperwork done. Caseworkers are able to get in there. Our union, we were able to protect, to safeguard and get official recognition of a camp in San Lorenzo Park for 3 years. And the city of Santa Cruz was compelled and was able to step up efforts to provide housing. In Novato, we had a camp that was created and officially recognized, Camp Compassion. And 40 people, maybe more, maybe the number went up, because they were stable, they were in the camp, they had food, they were accessible, they could do the paperwork, they could have the interactions, they were safe while they were doing it. We knew where people were. We got every single original plaintiff in that case got permanent housing. Camp Resolution in Sacramento, we were able to house at least 24 people, and we would have housed more if the city hadn't decided to reverse course and take the camp down. So you're right, Daniel. How can they even think about housing if instead they're pursuing policies that disperse the homeless and take them off of a path to housing? So that's a very important consideration.
Thank you, because I'm no longer homeless, and I'm very grateful I'm no longer homeless because of my boss.
Okay. We're grateful too, very grateful.
Thank you.
We have 10 days before the city council meets, and we're determined to make every effort between now and then to see to it that we organize community support and get ready. We want everything teed up and ready to go in the event that we have to maintain our position and seek the injunctive relief that we feel that we need to get. So of course we want as many people as possible to contact the city directly and express their viewpoint about this ordinance, and to attend the city council meeting on March 18th, so that we can show that we need to go further, and taking out language which is actually remains in the municipal code. That's no solution. That's a trick, and we want to see the ordinance repealed entirely.
So all I wanted to ask was, I was watching the radio interview between David Bonaclarcy and Mayor Rod Sylvan earlier, and Mayor Rod Sylvan said that, quote, anybody can sue anybody at any given time, so it doesn't require any authority. It doesn't require any basis, but anybody can sue. How do you respond to that?
I don't know what to say. It sounds like it's kind of a belittling what we're doing here and trying to show that we don't have merit to our lawsuit. If the city there's ways that the city can bring motions if they feel we have no merit. There's no merit to our lawsuit. They can file appropriate motions, a motion to dismiss. Then we anticipate that they will. I don't really want to engage with that comment like that. This is a serious issue, and we hope that the city of Fremont is going to realize that we mean business here. This is not a game for us. This is not a symbolic thing for us. And comments like that are not helpful.
Well, they're not.
From the mayor.
Ever since I moved here, and I assume before, Fremont has put a lot of time and money into getting awards as the most senior friendly, the most inclusive. You know, they're very, very into PR. But I've got to say, this if it's publicized, I really think it could be horrible for property values. And I don't think this is just a humanitarian issue. I think that people who are looking for houses are going to be steered away, and that might be something that the city council would be more interested in than the humanitarian side of it.
I would just respond by saying that the Homeless Union believes in housing for all. Everyone is entitled to live in a house. We think it's a basic human right. And we know that there's people in the city of Fremont that are struggling. They have a house now. They're struggling maybe with a mortgage payment. They're trying to get a loan modification that's being tough. We have people that are facing repossession and foreclosure. We have people living in apartments who are barely able to pay the rent, and they have to sacrifice other necessities to do that. We are of the opinion. We saw the fires in California, where people across the economic spectrum lost their housing. And we feel very bad. No one should have to lose their housing, and no one should have to go without housing. So I think you're right. I think the values of the property values are something that are an important consideration, and that's one of the city's concerns, and we share those concerns. But how can you have a community that people want to live in and come to and be part of, which has criminalized its residents, those residents who can't afford traditional housing? The burden on the city of trying to contend with the challenges of operating a city and diverting resources to fighting the homeless and the amount of money spent on enforcement of these ordinances and police departments and code enforcement. None of this is in the public interest. And one of the elements of getting a preliminary injunction, which we're seeking, is to show that it's in the public interest to halt the city's ability to enforce this ordinance. and the diversion of resources away from what could go to housing and go to our children and go to community and health. And there are a lot of people behind those closed doors that are hurting. Our seniors, I don't know if you know, but the fastest growing segment of the unhoused and the homeless in the United States today are retired workers. And right up there alongside that are families and children. You don't see them. They're hidden away in the weekly rate motels and in the shelters and in other circumstances where they're unseen and hidden. But they're no less homeless and no less struggling and no less worried about that roof that they might have over their heads today and lose tomorrow by way of a natural disaster, a bank foreclosure, family medical. One of the largest contributors to homelessness today are family bankruptcies, primarily medical bankruptcies, where people are faced with a staggering medical bill for the lack of the requisite amount of insurance or whatever, and everything goes to take care of a loved one, and that house goes with it. That's just a tragedy that is totally avoidable. And so I think that we're all in this together, and I think that there's a shared commitment here. And so we want to see that manifested in this battle right here. We feel that this has national significance, and we're the union, for its part, is dug in. We're in here for the long haul. We want to win this important battle here, but we're in it for the long haul. And we think we can set an example here. I think we can set a national example here in the city of Fremont. And I think that that what we're doing here is it already has national attention. And so we can take advantage of that fact and make a national difference.
So I would say just quickly too that homelessness impacts us all, whether you're a business owner, a resident in a neighborhood, or somebody who is actually living and dying on these streets. And the way that we deal with impact is by putting people in housing, right? If the complaint is people living on the streets by all parties, then housing is the answer for that.
Does any other city have a similar ordinance to Fremont's? Or plan to do one?
Oh, similar to Fremont's. Yeah, there are. We haven't had a chance to look at all of them, but there's approximately 75 cities in the state of California that are either considering or have already enacted ordinances similar. They all feel that they have the green light to do so because of the Grants Pass decision. And we haven't had a chance to look at all of these ordinances, but there are very similar ordinances. But as far as we know, this is perhaps one of the worst, if not the worst, from the standpoint of what it now prohibits, the basis on which they can arrest a homeless person. As I said at the beginning of the tonight's event, if you read the plain language, they have made the act of living outdoors into a crime, and so on its face, this appears to be one of the worst. But there's others out there too. I want to point out though that we won an important victory in February, just last month, in Vallejo, California, and we have with us on the call tonight. We have some of the members of our Vallejo Homeless Union, and we were able to get an injunction to stop the city of Vallejo from removing a 64-year-old woman who has disabilities. They were going to come and kick her out of a place that she actually built with her own two hands, and we were able to successfully get an injunction to stop that from happening. As far as we know, it is the first injunction in federal court that prevented a city from removing a homeless person since the Grants Pass decision, the first in the whole country. And so it is possible to win. It is possible to win these legal battles. Our union has won its fair share of them. And I have to say that we're going to give it the best we can. This is a very difficult situation we're in. We want to see if we can persuade the city to avoid what is going to be a very problematic litigation going forward. And if we are able to do that, fine. But if we're not able to do that, we're going to put as many resources, commit them as much time as necessary to get the job done. But we need your help. We need your help. It's time for people to step up and realize that it's all for one and one for all. That's what I said. I addressed the City Council, the Fremont City Council, on Tuesday night. when we served the city attorney with our complaint. And I pointed out, it's all for one, one for all. We're concerned that people are going to, certain members of the community, certain organizations say, well, we got what we wanted. We're out of the line of fire. But there's others that are still in the line of fire. In fact, the majority of this ordinance still is going to have the effect of a very deleterious, tragic, and catastrophic effect on hundreds of homeless people in the city. So we hope that they'll step up and insist that everyone's rights have to be protected, and that we're not going to let them break up a unified approach to this. I think that part of the reason that the city did this and put out these statements, falsely reassuring some people, making perhaps some side agreements or making some kind of arrangements such that people felt that they were somewhat protected. Well, like we said at the beginning of this press conference, look at the code. You're not protected. You might be protected today, but you may not be protected tomorrow. And in any case, you can't perform the good works that you wish to perform, have been performing. You're not going to be able to protect them. You're not going to be able to carry out those charitable, your charitable mission. Your mission is compromised immediately by the criminalization of those that you are holding yourselves out as hoping to support. But we got work to do now. At a certain point in time, the talking has to end and the action has to go forward, and we're looking for that now. I'm talking from as sincerely as I possibly can. Which side are you on? Everyone in this country needs to start figuring out the answer to that question. California has 8 million people living at or below the poverty line. We are the wealthiest state in the country and the fourth largest economy in the world. And we can't figure out a way to stop we can't figure out a way to have people housed when we have the technology to build a 3D printed house in 45 minutes, and we have people living in cardboard boxes and people living in the streets, and we have cities that are making conditions even worse than that for people who are barely surviving. It's time to line up and kick in and do the right thing. And I want to lift up the plaintiffs who have signed on to this lawsuit. They asked us questions. We met with them. We had frank and honest answers, and they're courageous.
Hi, I'm Penny Nance from Washington, D.C. I have only a 2-year college degree, and almost half of my college classes and the textbooks had Maslow hierarchy in it. And this goes all against that hierarchy. Having the 3 basic things, and when you reach the hierarchy, you turn around and you try to help somebody, to reach those 3 things. A home and to be able to feed yourself and shelter. Kent's that kind of angle, that where all these college universities and are actually teaching, the hierarchy, its importance, because it was in over half my classes I had. Just seems ridiculous that we are going through something like this, but yet being taught stuff like this in college, but it's not really being practiced in real life with the law.
Use that theory, and it is something that is common people understand and people get, but it's things that political people choose not to look at. And so
I wanted to say a couple things. One, God gave us 2 hands for a reason, one to help ourselves and one to reach back and help another. That's first and foremost, and love thy neighbor. Secondly, is these ordinances that Fremont, the city of Novato, where I'm from, basically are threatening my summer plans with my kids, for instance. I need to think twice now about having a picnic And if I'm going to bring a blanket for everyone to sit on, or romantic night under the stars, or how about the movie or the music in the park that the cities put on? Like, are we not going to be able to have a blanket to lay down, to be able to enjoy such events? It's just mind-boggling.
Hi, everyone. Thank you so much for your tireless work in addressing this. My question was, what is the strategy on the ground until the 18th? Are frontline service workers trying to move people out before something further happens with the city? Are folks still providing the services? So can you shed light a little bit on what the strategy is right now for the community and how we're supporting the unhoused?
Oh, listen, I'm gonna say we're not gonna get into that here in this particular forum. I'm sure you understand this is kind of open to the public, and we're definitely looking at how we're going to see to it that people are not harmed, and are not, as best we can, to see to it that people are not harmed, no matter what happens. And we're not going to get into that here. I don't mean to pour cold water. We can discuss this with you in an appropriate forum, but we need to move forward here. And we're moving forward on all these different fronts. But believe me, we're going to take whatever steps are necessary. I just coming back to this. I'm going to have the final word on this. Is that we need to? This is the task before us now. And we're calling on people to step up to it. Is to unify, close ranks, and see to it that this ordinance is repealed, and that the city is not permitted to go forward with it and to enforce it. Anything short of that cannot be reconciled with a representation that we're on the side of the homeless. If the city of Fremont gets away with this, it's going to be a very difficult state of affairs across the state and across the country. We saw that. Grants Pass was a small little town that enacted an ordinance that was highly problematic. And it was challenged on the basis of the 8th Amendment, and the Supreme Court said, no, we think that the little city of Grants Pass has the right to pass this ordinance, and we don't think it's cruel and unusual punishment. Small town that made a huge difference in the wrong direction. And Fremont's a bigger city, but it's still a town in California, and we think here we can make a difference. So with that, I think we need to close, and I want to again say we hope we hear from our community members across the board now. And the next 10 days are going to be critical. There isn't a day that's going to go by that we don't continue both on the legal front, the organizing front, the political front, and the front of the narrative, the true narrative that we have to share in the court of public opinion. So
with that, we will thank all of you guys for coming, and we want you to remember that homelessness impacts all of us, and ordinances that happen in one small town impact the entire, state, nation. And we want, for you guys to know that you are appreciated for all of the work that you do, whether you are a case manager, somebody handing out socks, somebody that just takes the time to care about this community. We hope to see you guys on the next Zoom. And again, we appreciate all of you guys, and this fight will continue to stop impacting our community. And again, impact happens to everybody when homeless people are living on the streets. You guys take care. Have a good night.
Good night.